So, 3 million pages of documents, 180,000 images, and 2,000 videos. The latest release of files related to the pedophile Jeffrey Epstein is shocking in its size and its content. Investigations are now underway in at least 10 countries. We're still combing through the detail, and every day we uncover more and more about the crimes of the disgraced financier and the people he was connected to. Well, over the next half an hour, we'll discuss the key revelations uncovered so far and the seismic impacts they've had. The term Epstein Files does not refer to one single master document. It is a broad label used to describe thousands, and now millions, of pages of legal, investigative, and court-related materials connected to Jeffrey Epstein. These files were created over decades through federal investigations, civil lawsuits, criminal indictments, depositions, search warrants, and evidence collection. They include FBI reports, Department of Justice correspondence, court transcripts, financial documentation, flight logs, digital records, and evidentiary materials gathered during multiple probes. The phrase became widely used by media outlets and lawmakers as shorthand for the total archive of government-held material related to Epstein and his known associates. Several major records have already been made public through legal processes over the years. These include the 2008 Florida plea agreement, the 2019 federal indictment in New York, charging Epstein with sex trafficking of minors, and extensive court filings from the prosecution of Ghislaine Maxwell. In addition, numerous civil lawsuits resulted in depositions and documents being unsealed by court order. Flight logs from Epstein's aircraft surfaced through litigation. More recently, a large-scale document release included millions of pages of investigative records, emails, and digital evidence. These materials were released through formal government compliance procedures rather than unauthorized leaks. Despite the significant volume of material now public, certain categories remain sealed under federal law. Grand jury records are protected by strict secrecy rules in the United States and cannot be disclosed without a court order. Sensitive victim identifying information is legally protected to preserve privacy and safety. Some internal investigative communications remain restricted, particularly where disclosure could compromise methods, confidential sources, or related cases. Courts also retain authority to keep specific filings sealed if legal standards require it. There are clear legal constraints governing disclosure. And first, grand jury secrecy rules are codified in federal law and are designed to protect the integrity of the judicial process. Second, victim privacy protections require redactions of names, identifying details, and certain evidence. Third, due process rights apply even to individuals who are not charged with crimes. Finally, some materials may include classified or law enforcement sensitive information. Even in high-profile cases, transparency must operate within statutory limits established by law. Public confusion often stems from misunderstandings about legal terminology. Sealed does not mean destroyed. It means restricted by court order. Redacted means portions are blacked out for legal reasons. Unsealed refers to documents that were previously restricted but later made public through judicial approval. Additionally, references to millions of pages can sound dramatic, but investigative archives often accumulate large volumes of routine paperwork over long time periods. The size of an archive does not automatically indicate undisclosed revelations. The Federal Bureau of Investigation conducted multiple inquiries into Epstein over the years. These investigations generated search warrants, interview transcripts, evidence inventories, and digital forensic reports. After Epstein's 2019 arrest, federal agents seized materials from his residences, adding significantly to the documentary record. These records form a large portion of what is commonly described as the files. Jeffrey Epstein died in federal custody in August 2019. His death legally ended the criminal case against him. However, investigations into related matters continued. His passing also complicated potential prosecutions of alleged co-conspirators, as prosecutors could no longer leverage his testimony or pursue trial proceedings against him directly. In 2021, Ghislaine Maxwell was convicted in federal court for her role in assisting Epstein's abuse of minors. Trial transcripts, evidentiary exhibits, and sentencing memoranda were entered into the public record. This trial produced substantial additional documentation that is now accessible through court databases. Multiple civil lawsuits were filed by victims against Epstein and related parties. Through these cases, depositions were taken under oath. In some instances, courts later ordered portions of these records unsealed after media organizations petitioned for access. Civil litigation has been one of the primary mechanisms through which previously confidential material entered the public domain. The most recent large-scale release involved millions of pages compiled over decades. Officials stated that the release was conducted in compliance with applicable legal obligations. The materials include written records, digital correspondence, financial documentation, and multimedia evidence. Due to the volume, agencies acknowledged the complexity of reviewing and redacting sensitive content before publication. Following publication, authorities confirmed that certain identifying details related to survivors were inadvertently disclosed and later removed. Such redaction errors can occur in large document productions and are typically corrected once identified. Media organizations have emphasized caution in reporting to avoid amplifying sensitive information. Members of Congress have sought briefings and document access as part of oversight responsibilities. However, Congress does not possess prosecutorial authority. Its role is limited to legislative review, hearings, and potential recommendations for further legal or regulatory action. Some documents reference individuals or institutions outside the United States. The appearance of a name in correspondence does not constitute evidence of wrongdoing. Law enforcement agencies in various jurisdictions assess any relevant information under their own legal standards. Federal prosecutors have publicly stated that criminal charges require sufficient admissible evidence that meets statutory standards. The existence of documents alone does not automatically lead to prosecution. Each potential case must satisfy evidentiary thresholds, including proof beyond a reasonable doubt. Further document reviews may continue, and courts retain authority to unseal additional materials if legal criteria are met. Advocacy groups continue to call for transparency, while legal experts emphasize compliance with established judicial rules. The long-term outcome depends on ongoing review processes, court decisions, and legislative developments. If you found this video even slightly informative, then definitely subscribe to my channel. The next video on this topic will definitely come. More evidence is yet to be presented.